The clerk will call the court to order.
Oh yay, oh yay, oh yay. The Honorable, the Supreme Court of Texas. All persons having business before the Honorable, the Supreme Court of Texas are admonished to draw near and give their attention, for the court is now sitting. God save the state of Texas, this honorable court.
Good morning. The COVID-19 pandemic has required many adjustments of the justice system. Social distancing and group size restrictions, as well as potential hardships on counsel of travel to Austin, do not allow us to hold argument in the courtroom. Rather than submit cases without argument, we have decided to proceed through remote connections. Court staff has made every effort to prepare us and counsel, but of course, there may yet be glitches which will require patience. Otherwise, we will proceed in the same manner as we would in person. The arguments are being live streamed this morning, and a recording will be available later in the day. The court is ready to hear argument in 18-1167, the El Paso Education Initiative Incorporated versus Amex Properties from El Paso County in the 8th Court of Appeals District.
May it please the court, Mr. Hood will present argument for petitioner. Petitioner has reserved 8 minutes for rebuttal.
Mr. Hood.
Mr. Chief Justice, and may it please the court. Today's case raises two important issues that arise under Chapter 271 of the Local Government Code, which is the Local Contract Claims Immunity Act. The first is one which the court has never addressed, and that is what constitutes proper execution of a contract for the purposes of waiving the entity's immunity. The second is a recurring question that arises in terms of the damages that are recoverable under the Act. I'd first like to address the issue of proper execution of the contract. When the legislature enacted Chapter 271, providing for the waiver of immunity for certain contract claims involving contracts between private parties and local governmental entities, it was faced with the usual clash of political interests. The first, of course, is the interest of the private party contracting with the governmental entity in ensuring that the private party has a remedy in the event of a breach of the contract by the governmental entity. The second is the public interest, which arises in every case involving the question of governmental immunity, and that is the protection of the public fisc. To that end, the legislature imposed 5 requirements before immunity could be waived. The first is that the governmental entity must have the authority to contract. The second is that the contract must be for the provision of goods or services. The third requirement is that the contract be in writing. The fourth requirement is that the essential terms of the contract be spelled out in that writing. And then the final requirement, which is at issue in this case, is the contract must be properly executed on behalf of the governmental entity. These requirements, in essence, determine how a contract must be formed for the purpose of waiving the governmental entity's immunity. As this court made clear in City of Denton versus Rushing, for immunity to be waived, there must first be an enforceable written contract. In this case, immunity was not waived. Here, no enforceable contract was formed because Iris Vernon did not have the authority to bind the school to the lease that she signed.
Mr. Hood, how dependent is that inquiry on the agency rules itself? It seems to me every agency could create any number of rules to expand or limit that inquiry.
Well, the agency's rules, Justice Guzman, determine how a contract must be formed. They do not speak to the question of immunity one way or the other, but it is an authority that the agency has been vested with by the Texas legislature in the education code. The commissioner and the agency clearly have the authority to dictate not just to charter schools, but to public schools in general, how they must go about doing contracts with private entities. For example, there are competitive bidding requirements. There are provisions as well in the education code that apply to traditional independent school districts. So there's nothing terribly unique about the fact that an agency that governs the conduct of a governmental body sets forth rules on how that entity goes about contracting. And here there are three undisputed facts that show Ms. Burnham did not have the authority to bind the school to the contract that she signed and thus waive its immunity. The first is that this contract calls for the expenditure of $3 million in public funds over a 10-year period. TEA's regulations on this issue couldn't be clearer. They required the school board acting as a body corporate to approve the lease, the transaction. Second, it's undisputed that Ms. Burnham, when she signed the lease, did not have the actual authority to do so. There was no board resolution authorizing her to sign the agreement, nor was the lease ever presented to the board for approval after it was signed. There is no issue here with respect to ratification.
Excuse me, Mr. Hood,
Yes,
but she had made representations to the board that they were negotiating and that they were in active pursuit of entering into the lease and in determining what the terms of that would be. And so does that make any difference when you are looking at the language on behalf of, when it's made clear that she certainly was working on behalf of the board in that sense?
It does not, Justice Lehrman, as the Court of Appeals for the 5th District made clear in the LPTS case on remand from this court, the authority to negotiate is different from the authority to bind. In that case, there was a similar argument which the Dallas court rejected, and this court, of course, denied the petition for review. I would also add that her lack of authority was called to the attention of Mr. Firth, Amex's lawyer, as he acknowledged in an email to Mr. Wallace, the attorney for the school district. There was a requirement that the board approve the lease itself, and he asked for that resolution. There is no evidence in this record, because it didn't happen, that approval was ever transmitted to him. The third requirement, the third factor, pardon me, as to why there are no disputed facts in this case, is that it's clear from the record that the school's charter as originally adopted and subsequent amendments to the charter did not contain a delegation amendment approved by the Commissioner of Education that allowed the board to delegate its authority to Ms. Burnham. Under those three undisputed facts, the conclusion is inevitable. Any attempted delegation of the board's authority would, in the words of the regulation, have been null and void and of no force or effect. Under these circumstances, you could not have an enforceable contract as City of Denton versus Rushing requires. It's also important that Amex does not dispute any of these facts, nor does it dispute the applicability of TEA's regulations. Instead, it claims that fact issues require an evidentiary hearing and apparently a trial on the merits for three reasons. The first is that the school had the authority to contract generally. The second, as you pointed out, Justice Lehrman, is that Ms. Burnham admittedly had the authority to negotiate for the school. And the third is, and this is constantly emphasized by Amex, Ms. Burnham signed the lease as president of the school board, ostensibly on behalf of the El Paso Education Initiative, Inc. Now, the Court of Appeals accepted that argument, but that evidence, even if you accept it as true, and there are really no disputes over that as well, can't overcome TEA's directive that Ms. Burnham couldn't do what she purported to do, and that's to exercise the board's authority as a corporate body to bind the school to a contract that this board never saw, much less ever approved.
Did the district raise Ms. Burnham's lack of actual authority in its jurisdictional plea in the trial court? The Court of Appeals mentions in a footnote that the issue wasn't.
I'm sorry, Justice Bland, the last part of your question cut out.
Oh, Well, I think the Court of Appeals mentions in a footnote that the district did not raise Ms. Burnham's authority in its jurisdictional plea. Is that right?
I will concede that the word authority was never used in the answer. There was a verified denial that the school was not liable for her actions as required by the rules of civil procedure. And in the jurisdictional plea, the district did set forth all of the requirements of TEA's regulations, and it indicated, or it stated explicitly that she couldn't bind the board. It didn't say that she lacked apparent authority. It simply said it doesn't matter that she signed this agreement. She did not have the authority to do so. And so I don't understand their claim that there was no argument over actual authority, because that's what this case is all about. Do those regulations in this case trump whatever circumstantial evidence exists that might, in the context of the contract between private parties, allow Amex to claim that she had apparent authority to bind the school district?
Mr. Hood, yes. What would be an entity like Amex with the remedy, having been misled down by the school here? Do they have a duty to inquire further under these circumstances, make sure that there's the authority, or if they act on the basis of the misrepresentation or the representation of authority and incur damages, what is their remedy?
Well, I think your question somewhat answers itself, Justice Green. They do have a duty to inquire as to her authority. It has been settled Texas law for more than 100 years that entities that contract with public bodies do so presumptively knowing the limits of authority of the person that they are dealing with. And while it may seem harsh at first glance, the fact of the matter is that there are two good reasons for requiring that and holding private parties to that standard. The first is that if you're going to allocate losses, it's better to have it on the contracting parties rather than innocent taxpayers. The second is that Amex and private parties are in a position to inquire as an initial matter whether an individual does or does not have authority, whether or not additional approvals are required. By contrast, if you were to shift that burden to the entity and in effect to the taxpayers, they can only look at it after the fact, after the damage is done. And so while it may seem harsh, it's settled law and there is no unfairness in it, from our perspective. And in certain instances, there will be a remedy for these ultra-virus acts. And that's the obvious purpose of the proper execution requirement, to protect public entities from the ultra-virus acts of officials and employees. It certainly wouldn't be appropriate, for example, for an employee of the court to sign one of these court's opinions, or this court's opinions. Now, that's an extreme example, but it points out the reason behind these rules. And giving substantive effect to the proper execution requirement is important in this case, because charter schools receive public funds from the Foundation School Program, and they hold those funds in trust for the students.
Mr. Hood, is it possible or that the representations of your attorney to Amex could go toward actual authority? For example, indicating to Amex that Ms. Burnham is signing on behalf of the board. Why would that go to a parent authority? Isn't that more like she has authority to sign this? Do you dispute your attorney made statements like that? And if he did, are they relevant to our inquiry?
Well,
or she, yeah.
Well, it is a male. Jerry Wallace is a man. There's no evidence that he ever communicated to Mr. Firth, Amex's attorney, that the lease would be signed in the form that Amex sent over. That's just not there. There were internal communications between Mr. Wallace and Rebecca Gonzalez, an employee of the school district, explaining what Ms. Burnham would have to do and what she should do with respect to signing the agreement.
Mr. Hood, they make that representation on page 16 of their brief. I guess you disagree that the record would support that.
I do, and we pointed that out in a footnote in our brief, Your Honor. And I would suggest to you this: Mr. Wallace's representation is no more effective than the written representations contained in the acknowledgement that Ms. Burnham signed. All the representations in the world cannot change the undisputed fact that Ms. Burnham did not have the authority to act for the board. TEA's regulations flatly prohibit her from doing what Amex says this court said she ought to be able to do: bind the school district to a contract that its board never saw, much less ever approved.
Mr. Hood, this is Justice Boyd. If I can interrupt, just because I see your time is expiring, and I know you want to get to the damages question as well. But both the properly executed and consequential damages arguments are arguments as to why 271 doesn't waive immunity. And to be honest, I'm still a little hung up on whether immunity applies at all. So can you just very briefly describe the legal authority that you rely on for the proposition that sovereign immunity or governmental immunity protects El Paso Initiative?
Governmental immunity protects open enrollment charter schools, such as the El Paso Education Initiative, as a matter of judicial declaration, as well as the legislature's ratification of that declaration. LTTS, as Justice Guzman pointed out in her dissent in the case, effectively said that an open enrollment charter school has the same immunity as a traditional public school district would have. On remand to the Dallas Court of Appeals, the court held exactly that governmental immunity did attach to open enrollment charter schools because they had the same immunity as public school districts. The legislature subsequently affirmed that in, I believe it's section 12.106A of the Education Code. I would also add that there has never been any dispute that governmental immunity does not apply to the charter school. The only argument that has been made is that it is somehow unfair to insist that that immunity be applied to it. I'm not sure if I answered your question in its entirety. In my last minute or so, I would like to address the damages question.
Go ahead.
This court, beginning with the Kirby case and later in the H.B. Zachary case, has struggled with trying to determine what damages are recoverable and when is immunity waived for claims for damages. The damages sought here are plainly consequential damages. They were labeled as such by Amex. In addition, they cannot possibly constitute the balance due and owed under the contract because the only thing that was due and owed under the lease were rental payments. I see my time is expiring in 13 seconds. If there are no questions, I'll reserve the remainder of my time for rebuttal.
Any other questions? Thank you, Mr. Hood. We'll hear from the respondent.
May it please the court, Mr. Paoli will present argument for the respondent.
May it please the court, Mr. Chief Justice. One troubling aspect about EPEI's argument is that it is relying on what is normally and consistently recognized as affirmative defenses to a breach of contract claim as a basis to suggest that courts lack jurisdiction to even hear and consider the breach of contract claim that it's at issue. If this were a private party dispute, there's no dispute that a claim of illegality, a claim of voidness would be properly raised as an affirmative defense, not as a means to suggest that a court has no subject matter jurisdiction to consider the claim. We submit that EPEI's arguments and attempt to rely on those affirmative defenses is contrary to this court's decision in Jefferson County versus Jefferson County Constables Association, in which the court rejected the county's argument that the CBA was void and unenforceable because it violated certain provisions in the government code. The court in that case held that the county's claim of illegality did not affect the court's subject matter jurisdiction to hear and consider the breach of contract claim that was at issue, even despite the county's claim that the underlying CBA was void. We believe that that's the same deficiency that affects EPEI's arguments in this case. Worse yet, EPEI does not rely on a statute from the legislature to suggest that somehow this contract and this lease should somehow be held void, but they go a further step and try to rely on agency regulations promulgated by the TEA to suggest that that should somehow deprive the trial court and this court of subject matter jurisdiction to hear and consider the contract claim. We would submit to the court that that's contrary to what this court has normally recognized concerning limits on the scope of agency jurisdiction and power. In Continental Casualty Insurance versus Functional Restoration Services, this court in footnote 5 recognized that an agency's rulemaking power does not validly expand or create district court jurisdiction beyond that given by the legislature and its statutes. So a necessary corollary to that is that if an agency's rulemaking power cannot validly expand or create district court jurisdiction, I would submit to the court the problem with EPEI's argument is that they're trying to say that TEA regulations can somehow take away jurisdiction over breach of contract claims that are asserted under Chapter 271.
Mr. Paoli, when are the substantive limitations on, an individual from binding a government entity and waiving immunity it would otherwise enjoy?
Your Honor, you broke up just for a second. Can you repeat the question again?
Apologize. I'm thinking that there have to be some limitations on an individual's ability to bind the agency, and what would those be if we completely ignore substantive limits by the agency?
Well, I don't think that the argument by Amex is trying to suggest that all substantive limits from the agency need to be ignored. I don't think that's what we're suggesting. I think ultimately what's relevant here is that here you have a lease signed by a superintendent and board member. This is not a low-level employee of EPEI, and there's several significant indicia of authority in the actual lease that suggests that Ms. Burnham did actually have authority, or that should at least raise a fact issue concerning the extent of authority. And so, Justice Guzman, if this was a private party dispute, and it was between a private party plaintiff and a private party defendant, and the underlying agreement said that the document was executed on behalf of a corporate entity, the signature block said it was signed in a representative capacity, wouldn't those be the types of things that raise more than a scintilla of evidence on extent of authority for purposes of private party dispute? We believe yes, if the court's rules concerning what scintilla of evidence actually means should apply. So I don't know why EPEI can say that somehow the scintilla of evidence rules and the standard of evidence that rises to a scintilla of evidence should somehow go away merely because you have a governmental entity involved. Because after all, the intent of Chapter 271 as recognized by this court in Ben Bolt was to loosen the immunity bar so that local governmental entities that enter into contracts will have and face liability on those specific contracts subject to Chapter 271.
But Mr. Paoli, if in fact she did not have authority to enter into that contract, then what evidence could that be?
Well, the evidence would be the indicia of authority that are demonstrated both by the lease, the recitals in the lease, and the actual communications that went back and forth in terms of the board meeting communications, where Ms. Burnham communicated to the board that she was actually negotiating the lease. And so I would make reference to one case that is not a Chapter 271 case, but it's a case from this court involved called Bowman versus, I believe it's Lumberman Independent School District. And in that case, the court recognized that when you have a superintendent involved, the superintendent is not a low-level official for a school district, and that the superintendent's actions can actually be actions that are considered actions that actually bind the school district's board because the superintendent acts as an implied agent of the school district board of trustees.
And that may be true, but certainly it seems that it's not unreasonable for your company or your client to be required to conduct whatever type of due diligence is necessary to determine when authority really is proper, right?
True, but that has to be a two-way street, because keep in mind here, Your Honor, that the TEA regulations that are involved, that EPEI relies upon, there's no procedure for my client Amex to seek a delegation amendment from the Commissioner of Education. That is 100% solely a responsibility and an obligation that EPEI or an open enrollment charter school has. So even if my client had been aware of that particular issue back all those years ago when Ms. Burnham signed the lease, there's no procedure in the regulations for her to go to TEA and get a delegation amendment. The sole failure on behalf of the charter school EPEI was a failure by EPEI to follow the regulations promulgated by the agency that governs it. So when we're talking about fairness here, and I realize that fairness isn't the overarching standard, but when we're talking about really who it is that failed in the process, we would submit to the court that it was EPEI that failed in the process of trying to make sure that it complies with its own rules promulgated by its agency that governs it with respect to the lease that was actually signed. There was nothing my client could have done in terms of going to the TEA to actually get a delegation amendment to the charter passed. There's just no procedure in the Texas Administrative Code to that effect.
Mr. Paley, did your client request verification of board approval after the lease was signed? And is that one step that could be taken to verify that the board had approved not just negotiating the lease, but the actual final version?
Yes, Justice Bland. There was actually one email, and I believe it would have been before the lease was signed, where Mr. Firth, the prior attorney for Amex, asked Mr. Wallace, the attorney who was acting for the charter school, for information to suggest that the board had actually approved it. There was an email to that effect. That's in the record. And ultimately, I don't think the response was received from from EPEI that confirmed that. But the subsequent communications, if my memory, the timing is right, is that Ms. Burnham signed the lease thereafter. And when the lease contained certain indicia of her authority, which recited that it was being signed on behalf of EPEI, I think at that point in time, it was certainly reasonable for Amex to rely upon those indications, just like a private party would be able to rely on those indications of authority in connection with the lease. Ultimately, there's a concern here about proper execution. And I don't dispute that the legislature ultimately determined that proper execution is required. But it also determined that what we're talking about in terms of execution is proper execution on behalf of a governmental entity, not necessarily by a governmental entity. And that's an important distinction, because the common meaning of on behalf of is for someone's benefit or representing someone, which is different than saying it was done by someone. Merriam-Webster's dictionary definition is as a representative of someone or for the benefit of someone. And I think just a very simple example would be the teacher accepted the award and signed the certificate on behalf of the entire class. That's different from a situation in which there's a legal requirement for the word by to actually be used, because by also suggests in conformity with, as in the student or the teacher acted by the rules. And what happened here is in passing Chapter 271, the legislature focused on whether there was execution on behalf of the governmental entity, not proper execution by the governmental entity. And so we believe that the relevant analysis and the correct analysis is articulated by the Dallas Court of Appeals and Housing Authority of Dallas versus Killingsworth. In that case, the Dallas court held that we construe the phrase properly executed as referring to the discrete requirements or procedures outlined in statutes, ordinances, or documents that give the governmental entity authority, but that construction does not require, as part of proper execution, compliance with all laws and statutes that govern a particular entity before you can have a contract that is subject to Chapter 271. And in Killingsworth, the Dallas court rejected the housing authority's argument that an alleged unlawful approval of a contract somehow meant that the contract was not properly executed. In that specific case, the argument by the governmental authority was that somehow there was a violation of the Open Meetings Act, and that somehow made the contract invalid. And the Court of Appeals in that case said that that was not a bar to jurisdiction, and that the court still had jurisdiction to hear and consider the contract claim. I think the opinion in City of Houston versus Clear Channel from the Houston 14th District Court of Appeals is also relevant here. That case also makes the distinction between execution on behalf of a governmental entity and execution by a governmental entity. And in City of Houston versus Clear Channel, the Court of Appeals rejected the argument that the failure of the City Council to approve the contract at issue somehow prevented a determination that there was jurisdiction to consider the contract claim. Now, part of the reason why we think that those authorities are relevant here is because ultimately there can be a lot of different discrete requirements that a local governmental entity can impose. And I'm just going to use an example. It may seem extreme, but it's an example that I think has some relevance. If a city council and mayor were to say, before a city contract can be executed, a party must make a political contribution to the campaign of the mayor or a city council person who's up for election. That's certainly something that could be instituted in just by way of hypothetical, but that wouldn't necessarily preclude parties from entering into valid contracts that are subject to jurisdiction of the courts, for which courts should have an opportunity to ultimately resolve those types of claims. And if there was
Mr.
a failure, yes.
Can I take you back to Clear Channel out of the 14th Court, since I authored that? Aren't there factual differences though? Like no one in that case challenged the authority, and that is a big difference in my view. How do you respond to that?
Your Honor, I do think there are some differences certainly in Clear Channel, and I think the part of the problem in Clear Channel that was raised by the City of Houston was they tried to say the same thing that EPEIs were saying here, that the City Council should have approved it. And I think it's similar to what EPEI is saying in terms of, well, the Board of Trustees for EPEI should have also approved it. So yes, there are certain factual differences, but ultimately the end result was whether there was proper execution on behalf of the local governmental entity, and whether this body that allegedly oversees that governmental entity actually approved the contract that's at issue, and whether there's actually jurisdiction to consider that type of claim. So I don't think the factual differences are dispositive, because the ultimate issue of whether the actual entity that approved the contract, that's the same issue that EPEI is raising. The only difference is they're saying it's their Board of Trustees, where Clear Channel dealt with a failure by the City Council. And I don't know that that's a distinction that has any difference.
To follow up on that and kind of loop you back into what you were arguing about the difference between on behalf of and by, if we were to agree with the initiative's argument here that the contract, the lease was not properly executed, then obviously, assuming immunity applies, there'd be no waiver and there'd be no jurisdiction and you would lose. But would you also necessarily lose on the merits if there were no immunity? If we find that, if we agree with the initiative argument that the contract was not properly executed, does that mean that you would necessarily also lose on the merits because there is no binding contract?
Let me make sure I understand your question. I think I understand the first part in terms of whether if the court agrees with EPEI on the lack of proper execution. But the second part of your contract, I didn't follow.
So obviously the argument here by the initiative is that Chapter 271 does not waive governmental immunity because Chapter 271 requires proper execution. And according to the initiative, there's no proper execution of the contract here. Therefore, no waiver, therefore no jurisdiction, and you can't pursue your claim. My question is, because I'm trying to understand the argument you were making about the distinction between on behalf of and by, execution on behalf of and by. If we just hypothetically assume we don't have to worry about immunity here, and it's just a question of whether you can enforce this contract, if the El Paso initiative is correct that the contract was not properly executed on behalf of the initiative, does that mean you lose on the merits? In other words, there is no binding contract setting immunity aside altogether?
No, I don't think so. And the reason why I don't think that's the case is if there's no immunity here, then there's a question in my mind as to whether the dictates of Chapter 271 are the appropriate standards in terms of how the jury is going to answer the question. And if we're outside that context, certainly the jury, I think at trial, could be instructed on some of the rules that govern the extent of actual or apparent authority in the context of a contract that is executed on behalf of an entity. And so if you take away the immunity issue, then these concerns that EPEI raises concerning actual authority versus apparent authority, in my mind, they go away. And I don't know that they're dispositive and would necessarily mean that EPEI would prevail on the merits. And Justice, let me bring up a point that I...
If I can just follow up then. So El Paso Initiatives Council says that you've conceded all along that governmental immunity applies to and protects the initiative unless waived, and the argument thus becomes whether 271 waives it. Is that true? You've conceded that based on the Court of Appeals opinion in LTTS 2 or 3 or whatever it is, you've conceded all along in this case that immunity applies?
No, not immunity from suit. I don't dispute that LTTS decided the question of whether an entity such as EPEI can bring an interlocutory appeal to challenge a ruling on a plea to the jurisdiction. But I have viewed this case as presenting the issue of whether an open enrollment charter school does in fact enjoy immunity from suit. And I think the case that is relevant to the court's consideration on that is Neighborhood Centers versus Walker, which in that case, the court focused on 12.0156 and 12.0158 of the Education Code. And I'm not sure that Neighborhood Centers versus Walker, the way I interpret that decision, fully resolved that as a matter of law, open enrollment charter schools in every breach of contract claim would enjoy immunity from suit. The framework under that case is, is there a separate statute in the Education Code that would suggest that they are a governmental entity that enjoy immunity from suit? I don't know that there is. And so the question of conceding immunity from suit, I don't believe that's the case. And quite frankly, that was part of the reason why I thought maybe the court may be interested in this case, but that's just a lawyer's educated guess about what the court may be thinking on the case.
Well, we held in LTTS that a open enrollment charter school is a governmental unit under the Tort Claims Act and therefore can take an interlocutory appeal under Chapter 51. But then we held in Walker, Neighborhood v. Walker, that it is not a governmental body for purposes of the Whistleblower Act. So this court's never decided that question as to an open enrollment school, other than the fact that we denied the petition for review of the Court of Appeals decision in LTTS on remand, where that court did decide the issue.
That's correct, Your Honor. And I think that's ultimately an open issue. I don't believe we've conceded that in terms of immunity from suit. Our brief makes reference to the fact that one of the statutes in which the legislature purported to grant immunity from suit happened to be passed years after Ms. Burnham signed the actual lease that's at issue here. And so I think it's an issue that's presented in the case in light of kind of LTTS and how the framework in neighborhood centers versus Walker has actually suggested the statute, the inquiry on the jurisdictional point should go. Now, I've got about 3 minutes left. I want to make sure I address some of the arguments with respect to damages. The Court of Appeals focused really on one component of damages, but I want to emphasize there's actually two components of damages here. One of the components of damages are lost rentals. And that was not addressed by the Court of Appeals, but that's an entirely separate amount from the amount that is stated or that's really discussed in the parties' briefs concerning the construction costs paid to the contractor. And I want to make reference to a case that is not referenced in the briefs. It's Hoppenstein Properties versus McLennan County Appraisal District, 341 Southwest 3rd, 16. In that case, the Beaumont Court of Appeals recognized that lost rentals that a landlord seeks to recover under the actual lease that is executed rather than from some other contract are, of course, direct damages within the meaning of Chapter 271. And so there's an approximate balance of a little over $3 million because this was a 10-year lease that's at issue in the plaintiff's fifth amended petition that is entirely separate from this dispute that the court is considering concerning the construction costs paid to ABM. We believe that Hoppenstein recognizes that that balance for lost rentals certainly has to be direct damages. Now, with respect to the issue of the construction cost, I know that EPEI's attorney is suggesting, well, that there was this misstatement in the plaintiff's amended petition that categorized the damages as consequential damages. And I would point out to the court that in Pinto Technology Ventures versus Sheldon, a 2017 decision, the court recognized that the court focuses on the substance of the claim, not the label attached to a party's claim. I don't think that the label attached is dispositive. And here, we believe that the construction costs that are sought on behalf of Amex are in fact damages that are properly recoverable because the lease contemplates these specific categories of damages. The lease specifically says that in the event that Amex has to cure any breach or has to cure any default, that the tenant here, EPEI, is obligated to pay any and all costs and expenses incurred by Amex resulting from delays. And if there's any default that is cured by EPEI, that is cured by Amex, EPEI would agree to reimburse that. And so the construction costs paid out by Amex to its construction contractor, ABM, are amounts that Amex paid out to actually cure the defaults of EPEI. And that goes back to the fundamental rule recognized ultimately in Kirby Lake, is that when there's a balance due and owed that's incorporated into the contract, that's properly classified as direct damages, not consequential damages. And I think that's consistent with the language contained in section 271.153A2, which specifically contemplates that if there's a balance due and owing under the contract, that by definition is a recoverable element of damages that can be sought against a local governmental entity. So those provisions in the lease have relevance, they have to be considered, and they fit within section 271.153A1. So if the court ultimately reaches the issue on the merits, we ask that the court affirm. Thank you.
Any other questions? Thank you, Mr. Paoli. Mr. Hood, we'll hear rebuttal.
Mr. Chief Justice, I'd like to return to Justice Boyd's question on the threshold issue of whether or not immunity exists. The legislature resolved that issue with the amendments to the education code that essentially confirmed what the Dallas court said in LTTS on remand. The question of whether or not the district enjoys immunity is simply not an issue here.
Well, but you're aware, of course, of Justice Johnson's concurring opinion pointing out that we've still never quite decided whether the legislature can actually create immunity for a governmental entity, since it is a common law question. And that's a more complicated issue in and of itself, because the legislature certainly can create an entity giving it the attributes of sovereignty that we as a matter of common law would conclude would justify sovereign immunity. But whether they can actually pass a law that says this entity gets immunity is still an open question, isn't it?
Well, I think you could engage in a separation of powers debate about that, but it would be an unnecessary one, because the legislature essentially confirmed what the Dallas court said in LTTS. And really, as Justice Guzman's dissent in LTTS pointed out, the court in effect decided sub silento, and that is that that open enrollment charter schools do in fact enjoy governmental immunity. I think that point seems to me to be an unnecessary debate that the court does not need to get into in this case, or really any other, because there's no conflict between what the courts have said in terms of deeming an entity to be a governmental entity for the purposes of immunity, and what the legislature did in amendments to the education code after LTTS. I'd also like to highlight that this is a case that involves subject matter jurisdiction, not an affirmative defense. The school and the district have never contended that the lease was an illegal contract. The argument has always been that no binding enforceable contract was ever formed. Thus, there can be no immunity under, or pardon me, there can be no waiver of immunity under Chapter 271. That's explicitly what the court stated in the Rushing case.
And was it never formed from your perspective because it was not properly executed? Is that the argument?
Yes, and the reason it was never properly executed is that Ms. Burnham had no authority to bind the district as she purportedly did.
And in Clear Channel, the court drew a distinction between enforceability and proper execution. And why aren't those two separate inquiries? Or do they just run together here?
Because they overlap. They plainly overlap. And that's not unusual. In many instances, questions that pertain to immunity in the court's jurisdiction also go to the merits of the case. Courts confront that all the time under the Texas Commission on Human Rights Act in trying to decide whether or not a plaintiff has established a prima facie case of discrimination. There are other instances where that occurs as well, Justice Guzman. And I would say that
So your position, Mr. Hood, would be that if we agree with you that this lease was not properly executed as Chapter 271 requires, then you necessarily would also win on the merits if we ever had to get there, which of course we wouldn't, but that would also foreclose any claim on the merits?
It would, for this reason, and that is they're the same inquiry in essence.
Except your opponent raises apparent authority.
But apparent authority, if I will state that I agree with Mr. Paoli that if this were a suit between private parties, there would be an issue concerning Ms. Burnham's apparent authority to bind the district. But it has been the rule of law in this state since time immemorial that concepts such as apparent authority do not apply when you are talking about contracts and dealings with governmental entities. And again, the reason for that is protection of the public fisc and protecting innocent taxpayers, as well as placing the burden of investigation upon the party seeking to contract with the government. Mr. Paoli suggests that it was somehow unfair in this case and that Amex could really do nothing because only the school district could seek a delegation amendment to its charter. Well, that's a false proposition, because all Amex had to do is to follow up on Mr. First's statement to Mr. Wallace and say, can you please provide me with the resolution of the district's board approving this lease? That's all that had to be done. And it was not done in this case, and there's certainly no evidence of it in the record. He suggests that Bowman estoppel should apply in this case, but Bowman estoppel is limited to instances in which you are dealing with enforcement of a particular contract term or interpretation of that term. Here, you have a much more basic issue, and that is, was a contract ever formed? In Bowman and the La Villa Independent School District case that was decided after that, there was no question but that a contract had been formed between the school districts. And in Bowman, I believe it was the teachers, and in La Villa, I can't remember what the contract was, but a contract existed. It was simply a matter of estoppel with respect to interpretation of a particular term. So Bowman estoppel is limited, and it certainly could not be used to form a contract where one did not exist. I think that much is plain. The last thing I want to address on the issue of proper execution is the argument that somehow TEA has usurped the authority of the courts to determine when there is, and the legislature, when there is and isn't immunity and when it's been waived. Again, that is not our argument. The argument is TEA's regulations speak to what you have to do to form an enforceable contract. Whether or not immunity is waived in the process of forming that contract and whether a contract is formed is an entirely different issue for the courts. Lastly, with respect to the question of damages, under Mr. Paoli's reading of Kirby Lake, essentially any breach of any contract would provide for damages that could be recoverable in any context. That would effectively rewrite the statute to eliminate the prohibition on recovery of consequential damages that do not constitute the traditional sort of delay damages that the court held were recoverable in HB Zachary. With that, we would ask that the court reverse the judgments of the lower courts and render judgment dismissing the case for lack of subject matter jurisdiction.
Any other questions? Thank you, Mr. Hood. The case is submitted. We had hoped to hear argument in this case in El Paso itself with the court traveling out there, and never imagined that it would come to hearing argument this way. But we appreciate your arguments this morning, and the court will take a brief recess.